Now we look at paragraph F. Now this is a notice provision under the same notice FAA N16. Now this is regard to requirements on a financial advisor providing financial advisory services in relation to units in a collective investment scheme, where the units of which are excluded investment products. So this is known as EIP CIS. Alright, now the 2.9 reads, the following contains with regard to the requirements on a financial advisor providing financial advisory services in relation to units in a collective investment scheme, the units of which are excluded investment products under the FAA number 1616. Now quickly I want to refer you to Annex 1, okay, at the back of this particular chapter. Alright, now Annex 1 gives us the definition of what is meant by excluded investment products. Very quickly, can you please turn to Annex 1? Alright, it's at the back of the chapter. Alright, so Annex 1 there reads excluded investment products. Right? Now under 1, excluded investment product means A, B, C, D. Right? This is quite self-explanatory as which are the products listed under A to D are considered to be excluded investment products. Right? For the purpose of 1C, that's under paragraph 2, in terms of any unit in the investment-linked policy sub-fund, right? So that is a definition of the circumstances are all of the following. So C reads, 1C reads any unit in the ILP in the circumstances mentioned in paragraph 2 below. Right? Those are the circumstances in paragraph 2. And paragraph 2 has A and B. Right? So those are the circumstances. Or D, 2 or more products specified from A to C in this annex that are linked together in a stapled manner, such that one product may not be transferred or otherwise dealt with without any of the other products. So it's a staple kind of arrangement in regard to A, B, and C. Right? So those are the definitions. Those are the meanings of an excluded investment product. Right? So if you now turn back to turn back to F, right? Turn back to F of the chapter 4 under module 5 of the rules and regulations for financial advisory services. Now you will see that there is some notice requirement regarding units of a collective investment scheme, the units of which are excluded investment products. So these are excluded investment products. Now, importantly, I will just read to you 41A under 2.19 and try to go a bit slow on this one. Now, here remember that it is a CIS, right? A collective investment scheme. I read to you slowly. I try to explain that. Where the responsible person of the EIP CIS, right, excluded investment product under a collective investment scheme, is required to ensure that a customer account review, which we have talked about earlier, or a customer knowledge assessment, right, in terms of the listed SIP or unlisted SIP, referred in the notice earlier, is conducted by a financial advisor. So this responsible person, okay, of this EIP CIS requires the financial advisor to conduct on every client who is an existing relevant participant. Right? So this is an existing customer, as it were, existing relevant participant. Now, as a result of any change in the investment objective, 1, 2, investment focus, or 3, investment approach of this particular EIP CIS, which would cause the units in the EIP-CIS to be classified as a specified investment product. So what it means here is that the nature, the tenor of the product has changed. So there's a change in the objective, a change in the focus, a change in the approach. And because of this change, all right, then the unit now is classified as a specified investment product. It's no longer an excluded investment product. It becomes a specified investment product. All right. So then we have this problem, as you will know, that a specified investment product require either a CKA or a CAR. Right? Now, and in that particular situation where there's this change in the focus or the objective or the approach, and the financial advisor of this existing relevant participant is able to demonstrate to the responsible person, right, the responsible person of the EIP-CIS, that is unable to conduct either the CAR or the CKA, right? So you're unable to conduct this assessment, whether the client or whether this relevant participant has the necessary knowledge or experience to transact in the specified investment products, right? For reasons beyond his control. So the financial advisor say, hey, we beyond our reasonable control, we cannot contact this existing relevant participant, despite having written to the existing relevant participant regarding the conduct of the CAR or the CKA, and having made repeated attempts to establish contact with this particular existing relevant participant. So that's one way, right? We try to contact the relevant participant repeatedly, but we are unable to contact. Then the question is what to do. What's next? Because this has become a specified investment product, either listed or unlisted, right? Or it has contacted this relevant participant, able to contact this existing relevant participant. But this existing relevant participant refuses to undergo the CAR, the customer account review, or the CKA, the customer knowledge assessment. All right? Then how? Or this relevant participant agrees to undergo the CAR or the CKA, as the case may be. So the financial advisor now conducted the CAR or the CKA and found that, well, this relevant participant this relevant participant does not possess the adequate knowledge or experience either under the customer account review or the customer knowledge assessment, as the case may be. And because this relevant participant failed two tests, failed either of the tests, depending whether it's a listed SIP or a listed SIP, all right, then the financial advisor is going to tell this responsible person, hey, you cannot proceed to transact in the products. All right, so what to do? So let me just repeat that again. So what happens is now the financial advisor tells the responsible person under the EIP-CIS, all right, to say that, look, we are unable to conduct a customer account review or a customer knowledge assessment on this particular relevant participant. Either one cannot contact or can contact, but this relevant participant refuses to undergo the CAR or the CKA. Or the FA, the financial advisor, managed to contact this relevant participant, carried out the customer account review or the customer knowledge assessment, and found that the relevant participant does not possess the adequate knowledge or investment. Right? In this regard, therefore, this relevant participant cannot transact in the product anymore. Right? But if you look at the relevant sections there, the financial advisor may allow the existing relevant participant concerned to continue on to his existing position in the EIP and CIS. Right? So notwithstanding you cannot contact, or you can contact, but he refuses this person refuses to take the CKA or the CAR, or conducted the CKR or the CAR, but the relevant participant fails either the CAR or the CK, as the case may be, then the result is the financial advisors can allow this relevant participant to just hold on to the existing position. Just hold on, right? Or, on the instruction of this existing relevant participant concerned, execute a transaction or transactions on behalf of this existing relevant person to reduce his existing position in the EIP CIS. Right? So the outcome is either you allow the relevant participant to continue holding to his existing position in the product, in the EIP CIS, in the collective investment scheme product, or to reduce the position. Right? Now there is a caveat there at the bottom of that particular 41A, and I read to you: for the avoidance of doubt, the financial advisor shall not count such transaction referred to subparagraph 2 above, meaning to reduce the holding of the relevant participant, to reduce the existing position of the relevant participant. This transaction is not counted. All right, it's not counted as an investment experience for the purpose of the customer account review or the customer knowledge assessment for the existing relevant participant concerned. Now, I hope that is clear for you, right? Okay. So that is under paragraph F in chapter 4 relating to this particular issue where there is a change in the investment focus, or investment approach of the EIP CIS. Okay. I hope that's clear. Now, then we look at G, right? Now, G is similar again in thinking and logic as with F, all right, in relation to the EIP CIS. Now, G reads, requirements on a financial advisor providing financial advisory services in relation to units in an investment-linked policy subfund. Right? This is an insurance-related product, the units of which are excluded investment product. So it's a similar kind of issue. All right? Paragraph F refers to CIS, and paragraph G refers to ILP subfund, investment-linked policy subfund. All right? The notion is similar, all right? The following contents at paragraph 220, the following contents in regard to the requirements on the financial advisor providing a financial advisory services in relation to units in investment-linked policy subfund, the units of which are excluded investment products. All right, this has been extracted from FAAN 16 and is available at the MAS website as stated clearly at 2.20. Right? Now, 41B is similar to 41A, and I just read to you again, where the insurer this time, right, rather than a responsible person in regard to the EIP, CIS, here the life insurer is involved, the insurer is involved, issuing an investment-linked policy that has an EIP ILP subfund within the ILP, all right, is required to ensure that a customer knowledge assessment referred to the paragraph is conducted by a financial advisor on every client who is a relevant policy holder as a result of any change in investment objective or investment focus of this EIP ILP subfund or investment approach of the manager. Right? So it's a similar thing to the EIP CIS, change in investment objective, investment focus of the subfund, or the investment approach taken by the manager of the subfund, and which would cause the units in this EIP ILP subfund to be classified as specified investment products, right? Either listed or unlisted. In this case, generally, I guess it's unlisted. Okay. ILP subfunds are generally unlisted. Well, A is similar, and this financial advisor, all right, is able to demonstrate to the insurer concerned, right, that's unable to conduct the CKA, all right, as required by the MAS notices, right, and for reasons beyond his control, unable to contact the existing relevant policy holder, all right, having repeated attempts to do so, all right, or the policy holder, the relevant policy holder, refuses to undergo the CKA. All right, as I said before, this is usually unlisted, so the CKA is the relevant one. And the financial advisor has conducted the CKA and found that the existing relevant policy holder not to possess adequate knowledge or experience, right, pursuant to the requirements under the CKA. I will refer you to that later on, right? Unable to allow such existing relevant policyholder to transact in the unlisted specified investment product, which is the ILP. It has become unlisted specified investment product. Formerly, it was an excluded investment product. So, in this case, the answer is the same. The financial advisor may allow existing relevant policyholder to continue holding on to his existing position in this EIP ILP subfund, right? Can allow this policyholder to hold on to his position, right? Or on the instructions of the existing relevant policyholder concerned, execute a transaction or transactions on behalf of this existing relevant policyholder to reduce, right? I repeat, to reduce its existing position in the EIP ILP subfund. And similar to the EIP CIS, such a transaction in reducing the existing position shall not count as an investment experience for the purpose of the CKA. Now, I just want to pause a little while there and refer you to Annex 2, because we have been talking a lot about the customer knowledge assessment and the customer account review. So at this point, it is appropriate, I guess, to refer you to Annex 2 first regarding the CKA, and then we look at Annex 3 regarding the CAR. Okay, now can you turn to the back of this chapter, this particular chapter 4? Turn to the back. Now, if you look at Annex 2 at the back of the chapter 4, I hope you're on the same page. All right. Now, Annex 2 of the notice under FAA number 1616, criteria for the satisfaction of the customer knowledge assessment. Now, client who satisfy any of the following may be assessed as possessing the knowledge or experience in unlisted specified investment product for the purpose of the satisfaction of the customer knowledge assessment in specified investment products concerned. All right. So this is unlisted specified investment product. So when a financial advisor conducts the test, these are the criteria. All right. A, the client holds a diploma or a higher qualifications in accountancy, actuarial science, business administration, etc. All right. So you can see from 1A of the Annex 2 of this particular chapter, of this notice, Annex 2 of the notice found in Chapter 4, you will find that the diploma is the lowest qualification in terms of academic qualifications. Alright? So if a person has a GCE O level, GCE A level, well, that person may not qualify. Alright? You have, the client should have a diploma, some form of a tertiary academic qualification. Alright? Or higher qualifications, meaning a degree, alright, or a postgraduate diploma or a postgraduate degree. Now, the key thing is it must also be the relevant disciplines. Alright? You can see there accountancy, actuarial science, finance, engineering, finance, economics, computer, and so on, right? Now, if a person holds a diploma, say for example in history, all right, in geography or in human resource or some other non-financial or financial related qualifications, then the client may not qualify. All right, the client may hold a PhD, in for example, in archaeology, or in philosophy. So the likelihood is that it is not a qualification, an academic qualification recognized under this particular notice, right? So it must be business related, and capital markets related, commerce. So it must more commercial and finance related kind of qualifications. Because here we are talking about sophisticated products, all right, unlisted SIPs, right? So that's number A. Now, number 2, they expanded it to the client has a professional, again, I emphasize finance-related qualification. What does this mean? You cast your eye down to page number 3. They give you some examples, right? Chartered Financial Analyst Examination conducted by the CFA Institute. So you have a CFA qualification, all right, then you are considered all right. Right? So that is number B. And then coming down, you can see Association of Chartered Certified Accountant, ACCA, and so on. Right? So again, the professional qualifications are finance related. Right? So those are the two. One is academic, one is professional. Now then coming down to experience, C. Okay, the client has invested in the following unlisted specified investment products. Now, for transactions in collective investment scheme and investment-linked life insurance policy, the client has transacted in the CIS or the ILPs, as the case may be, at least 6 times in the preceding 3 years. Right? 6 times, at least 6 times in the preceding 3 years. Right, then you are considered as having met the criteria, one of the criteria to transact in the unlisted SIPs. Okay? So if you say 5 times in the preceding 3 years, well, may not be sufficient. It must be at least 6 times. This is to ensure that this particular client has the necessary experience. All right, it's the experience part in this particular point C. Right? Or for transaction in specified investment trusts, which are neither listed nor quoted on the securities market, on the futures market, excluding CIS and ILPs, the client has transacted in any specified investment products which are neither listed nor quoted, etc., at least 6 times in the preceding 3 years. Right? So those are the two under C, where you are deemed, or where a client is deemed to have the necessary experience. D, right? The client has a minimum of 3 consecutive years of working experience. Underline the word consecutive, right? 3 consecutive. In the past 10 years, in the development of, structuring of, management of, sale of, trading of, research on, and analysis of investment products, or the provision of training in investment products. So if you're a trainer, you can also be considered as having the knowledge and experience, all right, to transact in these sophisticated products. Right? Work experience in accountancy, actuarial science, treasury, financial risk management will also be considered as relevant experience. Right? So therefore, these are the criteria, right, that enable a person to have a positive outcome in relation to the customer knowledge assessment. Okay, I hope that is quite clear. Now, if you look again, you cast your eye down under 4, the page in terms of working experience. The notice also provides, notice FNN 16 also provides, such working experience will also include the provision of legal service or possession of legal expertise on the relevant areas listed in Lim D. All right. So under Lim D, or under point D, in terms of working experience, they also include legal advice. So if you are practicing lawyer in corporate finance, or you're a corporate lawyer in life insurance products and so forth, all right, and therefore you may be considered as having the knowledge to transact in the unlisted specified investment products. Okay, so not any lawyer can be considered having the relevant experience. All right, if you're a pure conveyancing lawyer, for example, all right, you may not deem to have the necessary knowledge, all right, to transact in unlisted specified investment. All right, if you're advising on perhaps, for example, structured products, you are a derivatives lawyer, all right, or if a lawyer dealing with funds, all right, in fixed income deposits and fixed income products, that type, the derivative style product, structured products, then probably that kind of working experience, all right, over a number of 3 consecutive years in the past, 3 consecutive years of working experience in the past 10 years, probably will qualify you to have the necessary knowledge to transact in unlisted specified investment products. Right? So those are some of the criteria under the CKA. Okay. And of course, if you cast your eye along the next page for that, a learning module provided by independent body as set out on the practice notes on recommendation of investment products. Under FAA PN02, the client may be deemed to possess the knowledge to transact in that unlisted specified investment product. Right? So sometimes the industry provides a special module, okay, by independent body. Of course, it must be a professional body, all right, that conducts a module regarding the knowledge in regard to the unspecified investment products. Right? So the practice note sets that out. And if you pass that particular module, then the client may be deemed to have that knowledge, right, to transact in the unlisted SIP. Right? Now that's in relation to the customer knowledge assessment. Now, all these requirements, as you can appreciate, is to make sure the customer in a way is protected. All right. So if the customer is deemed not to have the knowledge, then the financial advisor should not allow the customer to transact in such sophisticated products. Okay? Now then, very quickly we'll turn to the next page, Annex 3 of the notice under the FAA N16. Now this is the one regarding the criteria for assessment of the customer account review. Alright, so I just read to you very quickly under 1. A client who satisfies any of the following may be assessed as possessing the knowledge or the experience in derivatives, right? For the satisfaction of the customer account review in the specified investment products concerned. Alright, so these are specified investment products. Again, it is quite similar. Client holds a diploma or higher qualification in a finance or finance-related discipline, right? B, again similar, professional finance-related qualification, all right? And below that, you can see at the bottom of the page, they give you some examples, which the examples are similar to the one on the customer knowledge assessment. Right? Under C, then the client has transacted in the listed specified products at least six times in the preceding 3 years. So again, if you compare with the customer knowledge assessment, it is similar. Right? Right? It is 6 times in the preceding 3 years. Right? It's quite similar. Or the client has a minimum of 3 consecutive years of working experience in the past 10 years. Similarly, in the development, structuring of management of etc. All right, and then also work experience in accountancy, actuarial science, treasury, financial risk management, etc. And all these are considered to be relevant working experience. Right? So largely, the law regarding this area of conduct of business is similar, right? Right, and then of course, if you look at the paragraph 2 under Annex 3, again it is similar, where a client is assessed to not to possess knowledge, experience, but subsequently demonstrate sufficient understanding of the features and the risks of derivatives through a learning module provided by independent body as cited in the practice notes on the sale of investment products under the SFA, the Securities and Futures Act, PN 10. The client may be deemed to possess the knowledge to transact in listed specified investment products. Right? Okay, so that's that. So therefore, if a financial advisor corporation, all right, wishes client to transact in either unlisted specified investment products or listed specified investment products, then the financial advisor corporation may want to conduct courses for the clients to make sure that they pass the particular module, right, before they are deemed to be to pass either the CKA or the CAR, right? For these clients to be able to transact in either the unlisted or the listed specified investment products, right? Okay, so this is done. Okay. So I hope now you have a good knowledge of the criteria in relation to the satisfaction or the assessment of the CKA and the CAR. Okay, now let us go back to the main body of this chapter. Now, so that covers paragraph F, all right, the heading F of this particular chapter. Okay. The technical bit, as I've said before, is under F in relation to excluded investment product under the CIS scheme and under the ILP that has become either a specified investment product or an unspecified investment product. Okay, and what can be done if there's any change in the focus or the approach, right, or the objective of the respective products. Okay. Now moving on. Let's now take a look at paragraph H, right? Now paragraph H is also under the Financial Advisors Notice number 16. This H, under heading H, requirements on financial advisors providing financial advisory services in relation to overseas listed investment product. Right? Now this is overseas listed investment products, right? Now look at 41C under 2.21, right? 2.21. And I read to you very quickly. A financial advisor shall provide the risk warning statement set out in Annex 4 to this notice to its client before making a recommendation on any overseas listed investment product, where, underline this one, it is the first time on or after 8 October 2018 that the financial advisor makes such recommendation to the client. So that's the effective date there, which is on or after 8 October 2018. Okay? And this amendment came about as amendment number 3 in the year 2018. Now 41D reads, the financial advisor shall obtain the client's acknowledgement of the risk warning statement in written form or otherwise. Right? Possibly a digital form will do, before making a recommendation on any overseas listed investment product, where it is for the first time on or after 8 October 2018. Right? So again, they're emphasizing on the date, the effective date, on which the recommendation on any overseas listed investment product is made. Alright, now 41E, paragraph 41E, the financial advisor shall maintain records of the client's acknowledgement referred to 41D for a period of not less than 5 years. Alright, as I've spoken earlier in the earlier chapter, my suggestion probably will be 6 years, right? Where the limitation period for contract, the limitation period, the time bar period in Singapore in terms of contractual obligations under Singapore law is 6 years. All right. In this particular case, the FNN, the Financial Advisors Notice number 16 stipulated that not less than 5. So minimum 5 years. Okay, so the record must be kept, right, of the client's acknowledgement. Now, in terms of the acknowledgement, I will go to that later on, right? Let me just continue with 41F, right? Where the financial advisor makes a recommendation on an overseas listed investment product to its client, the financial advisor may implement a system to identify and determine that the overseas listed investment product is to be classified as an excluded investment product. Right? Underline the word excluded investment product. Right? Meaning it's probably relatively safe. It is not one of those specified or investment product. It's an excluded investment product. And I've drawn your attention to the definition or to the meaning or to the ambit of the excluded investment product earlier. Right? And I think the excluded investment product that I referred to earlier is is found in Annex 1 of this particular chapter, Annex 1. Okay. So you can cross-reference to Annex 1 to take a look at the range of products, the types of products that are considered as excluded investment products under Annex 1. Okay.